Batcher versus Pierce. Do we have everyone in the courtroom we're expecting for this case?
Yes.
Yes, ma'am.
If you want to, go ahead and come on up and we'll hear that argument now then. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when we get started, I am keeping the clock this morning and we'll keep you apprised of the passage of time. We've read the briefs and we're ready to see when you are. Okay.
I am Susan Pritchard, representing the appellant Ken Batcher, and I would like to reserve 3 minutes. The issues before the court today are primarily the tax dependency exemptions and child support. As the court is aware, this case has been here before. The case has sort of a long and convoluted history, but essentially the issues are pretty simple right now. After this court's decision, the case was remanded to the trial court. We did not have any further hearing of any sort. There was no new evidence taken, no new exhibits submitted. The court made its decision based on whatever it already had, and we just got a written decision from the trial court, which is a little bit difficult to understand exactly what the court, if you read it, there are paragraphs that say refer to this previous item, and it's not really clear what's going on, but the child support's pretty clear. And the tax dependency exemption is contained in one sentence close to the end of the decision in paragraph 19 and simply says, the tax dependency exemption will not be modified. And that's it. The original agreement was contained in a shared parenting plan. There are 4 children. Each parent was to claim 2, and that's what they've been doing. The original agreement in the divorce also provided that there was spousal support flowing from my client to ex-wife of $4,000 a month and child support of $842 per month. And under that scenario, they each claim 2, which makes some sense. She's going to have some spousal support that's going to be taxable, so here's 2 children that will help. The child support worksheet is not attached to the original decision. We don't know how that number exactly was arrived at, although I do indicate in my brief that you certainly can reconstruct it based on the information that was available to the court. And when you do that, it turns out that it seems clear that the amount of child support under the totality of the circumstances that were apparent at the time of the trial, back in 2008 I believe it was that they took the amount of child support of about $1,600 and cut it in half, and agreed that there would be $842 in child support. When Mother then filed her motion to modify, and we get the original decision, the magistrate initially had done a calculation, determined that it was indeed a change of circumstance of some sort, and calculated the child support at about $2,000 a month and cut it in half. And that's the decision that this court reversed. There, again, has been no real analysis that I can discern from the decision that we're currently before the court on. The court does say there's been a change of circumstance. Well, yes, it was $842, but now it's $2,000 or $2,100. That in and of itself is more than 10%. We all get that. But the case law says that you're to use the same methodology that was employed in the original child support calculation. Well, the parties had an agreement. They agreed to a 50% reduction. And again, it's our position that that's what the court should have done as a starting point. Not that they were necessarily obligated to maintain that, although I think that the case law would lead you in that direction. The parties have agreed on how child support is going to be calculated on this date, then that's the way it's going to be going forward. Absent some huge change of circumstance that we don't have here. Yes, there's very modest changes in income that don't really amount to a whole lot. We basically have the same facts. What changed is that the spousal support dropped off. So at the time that this decision is effective, we go all the way back to 2010. Child support is retroactive back to that date. At that point in time, Mother was a student, unemployed, didn't have any income. So why is she getting any tax exemptions? The reason, I think, is because she, again, the day that things are going to affect doesn't necessarily catch up with what's going on in reality. She's remarried. So the 2010 tax return shows that she's remarried, and in essence, her new husband gets the tax dependency exemption. But his income wasn't taken into account in making the determination of child support. Although the court is aware of it, the trial court had his tax return and knew what his income information was for that year, it's in no way considered in determining the amount of support. So we have an order that at one point, the first order says, well, it should be roughly, I'm speaking, $2,100 in child support, but I'm going to cut it in half without the necessary complete analysis that's required in order to do that. And then we get a decision without any new testimony that says, well, we're just going to do a straight calculation, and the amount is $2,100 and some change, and we find that to be fair, just, and in the best interest of the children. What changed? Nothing changed. The facts are exactly the same. No new information was presented, and somehow the trial court came to exactly the opposite conclusion. So the first issue we have is the tax dependency exemption. Again, it's our position, my client's position, that all 4 of those tax dependency exemptions should be with him. The case law on it is actually pretty clear. The Supreme Court case, Singer v. Dickinson, I believe it is, way back in 1992, indicated that the court could allocate tax dependency exemptions, of course, wasn't prohibited from doing that, but that a non-custodial parent could only be given the children as a tax dependency exemption if there was going to be a net increase in tax savings by doing that. There is no net increase in savings in this case at all by doing that.
Well, okay, so the argument, correct me if I've got this wrong, but
okay.
The argument seems to be, as to the 50% reduction in child support, the parties could prospectively bind the court under future determination, barring some humongous change in circumstances. But as to the tax exemption, which was equally split at the time, that doesn't bar the court from
I think it is barred. I think that if we had, as you'll notice, when the decision was $1,000 a month, the tax dependency exemption was left the same, okay.
Doesn't the separation agreement state specifically that the tax dependency exemption can't be looked at every single time that you go and reevaluate child support?
Sure, parenting plan?
Modifiable plan.
Well, I didn't write it, so I couldn't speak without actually looking at it. That would be a common thing to say. Obviously, the court retains jurisdiction over child support. I'm sorry that
And tax dependency exemption as well.
Okay, and I agree that it shouldn't be a mixed bag, right? If you're going to change the child support, then you ought to be able to change tax dependency exemption. But what we got was, initially, I think the court, if they'd explained the decision better, got it right. The child support is reduced because, primarily, my client's paying child support, and he actually has the kids more than 50% of the time. He has the son every Sunday evening, so it turns out to be that he has an extra overnight. So technically, he has the kids more than half the time. He's supplying their support during those periods of time. The parties recognized that, took that all into account, and said, okay, we're going to reduce the support, we're going to give you 2 of the dependency exemptions. Trial court, I think, saw that and followed that. Then on remand, I think what happened was the court just, it's sort of a knee-jerk reaction, okay, we won't cut it in half. But we're also not going to take any new testimony, we're not going to really do much of an analysis, we're just going to say, okay, Court of Appeals has told us we're not allowed to do that, which I don't think is what you said. I think you said you have to perform the correct analysis before you can reduce it by any amount. And so that they didn't. They took it, with all due deference, they took an easy way out and just said, okay, we won't reduce it at all. But then they didn't look at the tax dependency exemption. It would be one thing to say, okay, my client has to pay $2,100 a month in child support, and he gets all 4 of the kids. That makes more sense. Because really what we're left with is that the person benefiting is a non-party, the new husband.
But it's the household.
It's the household, but the statute doesn't talk about household, it talks about parent. And, we can't just change that. It talks about the non-custodial parent, actually, and of course we have shared parenting plans, so nobody's a non-custodial parent, but then we just have to say what's in the best interest of the children. And is that in the best interest of the children? And if that's the case, then shouldn't we be looking at his income for deviation?
And was that best interest analysis done?
In the new decision?
Was it?
There's one sentence. It says the court finds the amount calculated to be fair and just and in the best interest of the children. That's it. So if that's an analysis, then we did an analysis. I mean, that's it. There's no real discussion, there's no discussion of finances. There's no discussion of tax ramifications. It's one sentence. One sentence saying we're not going to modify the tax dependency exemption. Leave it alone as it is. So the other part of that is that now we've got, and it's nominally exceeding the $150,000, but my client's income is $151,000 pursuant to the court's determination of his income, which we don't dispute. We're okay with the numbers trial court use. I think they were probably stipulated in. But he's making $151,000. Mom, whatever her income is, was imputed because even though I don't think she was working at all in 2010, but when she has worked, it's nominal. So if they imputed minimum wage to her, now the combined income certainly is over $150,000, and there's no discussion of how that applies. This court's prior decision says, of course, you do the calculation, that's the starting point. It could be up, could be down, could be the same, but still it's the starting point for the analysis. And that's it. The court just said, okay, there's the amount of the calculation and we're done. No more thought went into it than that. It would have been better, I think, if we had been permitted an opportunity for hearing following the remand. And we were not. We just got a decision from the court and said, here's the way it's going to be. Or at the very least, if the trial court had gone back and said, well, I need to review the transcript and I need to look at what was said and what happened in the original hearings and make the determination based on that information, that didn't happen either. We just get a decision with the amount of child support set at the full amount and tax dependency exemptions split. So what we're actually asking is that it's either one or the other. I think the case needs to be remanded in order for the court to really do the proper analysis. I think the remand should encompass a new hearing, at which point there is an opportunity to either point in the record to the information that was already available to the court and the court didn't look at, or to present additional evidence if that's necessary to address the issue so that the court can conduct a proper analysis of both the dependency exemption and child support amount.
When you are coming up on that 3 minutes of rebuttal time, you see the reserve here.
Okay, thank you.
Your Honors, I'm a little befuddled by the ever-evolving appellant's theory of the case. And to understand what I'm saying, you have to go back before this court's last decision, before the hearing where evidence was taken.
Counsel, and I'm sure that most of us recognize you. It's usually good appellate practice to introduce yourself when you get started.
Oh, I'm sorry.
It's okay.
Michael Parlow here on behalf of the appellee, Serena Pierce. When this all started, and we have our evidentiary hearing, which, by the way, the appellant was given every opportunity to present any piece of evidence they wanted. The appellant's theory of the case then was that child support should stop. Okay, it wasn't that, oh, well, we should get a 50% deviation downward. It was child support should stop. And that's the evidence they presented. Their theory was there's a clause in the separation agreement or the share-sharing plan, I'm not sure which, that essentially says, and this is a crazy clause, I did not represent any party at the time this was drafted. Frankly, I think it's against public policy. It says that if my client, if the appellee's income, household income, ever exceeds $100,000, then child support stops. Craziest thing I've ever heard of. Fortunately for all of us, this court mooted it, because this court went through the record before and found that the appellee's household income was something in the neighborhood of 96, 97, 98, just under 100. You made that specific finding. That's the law of the case. The trial court on remand had to live with that. Okay, so now the appellant's theory evolves. Well, it should be a 50% reduction. The only problem is, at the hearing, if you review the evidence, you'll find that with regard to assignment of error number 2. Almost every aspect of what's being argued there, the appellant presented no evidence on. For example, the standard of living, the trial court should have considered the standard of living of the children. Well, the appellant should have presented some evidence on that both sides live in the Hudson school system. Both sides want to continue to do that because they don't want their children changing schools. Now, with regard to this tax dependency exemption, I think what the appellant really wanted was for the appellant, with all due respect, was kind of speaking with a forked tongue. It was saying, terminate child support. And at that point in time, that's what it was saying, terminate child support and give me all the tax deductions. Now that's insane. That makes no sense whatsoever. But beyond that, it kind of wanted the trial court to have a crystal ball. It was arguing that the appellee had over $100,000 worth of income at the time of the hearing, of the evidentiary hearing, actually hearings, I think there were 2. Yet, I should get all the tax exemptions because the appellee doesn't need them. Well, what may have happened in years after that, in terms of the appellee's income, is something that there's no evidence on, and there couldn't be. Trial courts don't have crystal balls. At the time we were in court, this was her income. Okay? Just under $100,000 as previously found by this court. Now, let's talk about the appellant's income, on the other hand. By the way, the statute does not say, there is no statute in the state of Ohio, nor is this in this court's prior decision, that a trial court in doing child support has to go through this whole litany of factors. If you present evidence concerning those factors, and the trial court is considering doing a deviation up or down, then it should look at that. If it's not considering doing a deviation, it doesn't need to. This court's prior decision, first of all, in its prior decision, it got reversed. The trial court did not cut it in half based upon, some agreement that doesn't exist. Read the shared parenting plan, read the separation agreement. There is no agreement that we're always going to reduce child support by 50%. It ain't there. It's that simple. They did, however, reduce child support at a time when the appellant was paying very large sums of spousal support. And we had no problem with that. We agreed to that. But when this was back before the court, the spousal support had ended, and the appellant's income had dramatically increased. The record is very clear that at the time that the parties entered into their separation agreement and the shared parenting plan, the appellant was earning somewhere between $120,000 and $130,000. Now, for that 1 year, the appellant did experience a situation where his tax return reflected not only his income, but also a hit he took by invading a retirement account in order to pay the appellee off for some things that he owed her. So for a while it went up. But in reality, what he was actually earning for child support purposes, now one-time events, which child support doesn't use, was somewhere between $120,000 and $130,000 at the time of the divorce. By the time we came to these hearings, he was earning $129,000 salary and another $35,000 in bonuses. Now the trial court took that and averaged it over 3 years of 35 and came up with 20-something. But not either event, you end up with slightly over 150. If you take the 35 as a whole, then you've got over 160. If you average it as the trial court did here, it goes down to just a little above 150. And I don't have a problem with that averaging, don't get me wrong. But that is much more than 10% of an increase of what he was making at the time of the parties' agreement. Now, there is a statute, so we're above the guidelines. He makes over 150. No matter what my client makes, we're above the guidelines. There's a statute on that, 31-1904B. And what it says is, you know, there's always been a fight for probably a decade or more about what do we do over 150, or at one point I think it was 180. You know, what do we do? Well, you know, for a while we were extrapolating and we were doing this and that. Now, essentially, what the statute says is you stop at 150. And that's the child support you order. In no event shall it be less than that, unless you make all these findings. The statute does not say you have to make all these findings if that argument is presented to you, and certainly if the evidence supporting any such argument is not presented to you. That's the case here. The appellant focused upon, well, you know, there should have been more proceedings. Well, this court didn't say that in its remand. And frankly, if you review the docket, it's not like it went back next door and a week later we had this new decision. It sat there for a long time. The appellant had every opportunity to request more testimony be taken, although I'm not sure why that would be. I mean, the appellant and the appellee had every opportunity to present all the evidence, you know, they wanted at the initial hearing. We're all Monday morning quarterbacks. We all sit there and think, boy, I wish I had done this or done that at the hearing, but the fact of the matter was the appellant was afforded a full hearing. There's an argument, I don't think it was discussed today, but I did want to address it because frankly one of the cases you find, and this is mine, it talks about you don't change child support when you've got a change that's contemplated by the parties. And I think that that is often misquoted or miscited. I think it's a very limited holding. Those cases usually involve situations where you are above the guidelines, okay? And in a divorce, you know, people agree, okay, I'm going to pay something in excess of what I have to pay. And then later on they want to modify it, you know, and take it back to what the real guideline figure is. And the court says, wait a minute, you contemplated, and in my case was a retirement. You know, you were here 4 years ago and agreed to pay this amount. And at that point in time, you surely must have known you were going to retire pretty soon. So why is there a change of circumstances? And they found there wasn't. But those cases are very limited. I think it would be a very dangerous proposition. Have a very chilling effect on settlements in divorce court in the 9th District if we had a situation where, okay, everybody knows when you order 48 months of spousal support, when 48 months goes by, it's going to stop. Okay, we all know that, there's no question. But if you were to then say, well, you can't premise a change in child support on that because everybody knew it was going to happen, I think that's really dangerous. I think I'm certainly not going to make any agreements of that nature. If a trial court had ordered it on its own, we wouldn't even be talking about this.
Doesn't the trial court always have jurisdiction over child support?
Absolutely, absolutely. And not only that, in this case, I'm sorry?
But not spousal support.
Not spousal support unless it retains it, yeah. In this case, fortunately, though, we don't really have to get into that because, as I said, there was certainly a huge change of circumstances in this gentleman's income, much more than 10% between the time of trial and the time of this hearing. Once again, I would appreciate it if you could look at the, I mean, it's always difficult when you're trying to argue a negative on appeal because I don't have anywhere in the record to cite to say that something didn't happen. I can't point you to a page. But if you look at the shared parenting plan and the separation agreement, you will not find any clause in there that says, we agree that child support is always going to be reduced by 50%. And in fact, if you read your last opinion, the one in reverse of trial support, that's not even what happened. I mean, that was outrageous. There, the trial court didn't order $1,000, it ordered $800 and some dollars. What it did was, it took the appellant's child support obligation and split it in half. When you do that, the child support guidelines are really allocate responsibility, financial responsibility to both parties, okay? So the payor makes this and the payee makes this and okay, here's you add those together and here's your overall figure, and of that, the payor is going to pay this percentage and the payee is responsible for that percentage. So when you take the payor's obligation and reduce it by 50%, you've actually given the payee more than 50% of the responsibility, because the payee is then responsible for 50% of the payee's or the payor's obligation and their own, whole obligation themselves. That's what really happened there. And what this court really did, as a final thought, it said, okay, there was, the trial court adopted a magistrate's decision in the last one. And there was a little section in the magistrate's decision which I believe had 3, maybe 4 factors that the magistrate considered in reaching this figure. And I was the appellant at that time, and I'm saying, wait a minute, first of all, one of the factors, I didn't even know what it was talking about. The other 3 weren't in the record. This court did not tell the trial court what to do, except to the extent that if you're going to do a downward deviation, you got to make the analysis and tell us why, so that we can look at it and see if it's equitable. On remand here, what the trial court opted to do, after much time had gone by and nobody submitted anything new, was, wait a minute, I'm not going to do a deviation. I'm going to run the figures, I'm going to see if there's a 10% change. If there is, then I'm going to go with the 150 standard figure. And that's what happened. As to the 60B, there is a third assignment of error. I would submit to you that the issues brought up in the 60B are precisely the same issues we've been talking about all day. They're on the record. Nothing new there was added in terms of affidavits or any type of evidence. The rule on 60B is very clear. You can ask for a hearing, but you've got to give the court whatever new things you're relying upon attached to your 60B motion. There was nothing attached because, frankly, there was nothing new. It's the same arguments. Consequently, the same defenses apply. 60B can't be used as a substitute for appeal, and I think that's what was really going on, because certainly they do move quicker than appeals, and that's just the way life is. Unless the court has any further questions, I believe that's all I have.
Seeing none, thank you.
Thank you.
Just briefly, Your Honor. Obviously, the overarching concern is best interest of the children. And I agree that we as litigants have the burden of proof, both of us, have the obligation to provide the court with the information that's available. There was a plethora of information available to the trial court that is not reflected in the decisions that we have received, either of them. At some point, it does become the trial court's obligation to do the analysis. And we weren't drafting the agreement. I think if we had provided proposed findings of fact or conclusions of law, things might look a little bit different. And things certainly do evolve. Things that are, as counsel is aware, that a lot of things happen that aren't on the record and so are not before you. However, that does impact the way that decisions are made at the trial court level in terms of what's going to be presented to the court when you already have an inclination of what's happening. And again, that's counsel's responsibility, and I accept that, certainly. I'm suggesting, however, to the court that in this case, we need to have just a better academic analysis of why the court made such an about-face without explaining its decision. The trial court appears to have the position that under no circumstances can we do a deviation, and I do not believe that's what this court intended for them to conclude. And then finally, just in response to the tax dependency exemption, if you read the brief of the appellee, there is not one case cited, not one statute cited that refutes our position on the tax dependency exemption. I take that to conclude that there isn't any. If there was something, they would have found it. I didn't find it. The case law is consistent. You're not supposed to be allocating tax dependency exemptions to a third party. They belong to the parents. And that the case law out of the 9th District says specifically that the exemption belongs to the person who has greater income, that is in the higher tax bracket. If there is no income, then there cannot be any grounds for granting that tax dependency exemption to that person without any income. So I'm asking the court to remand with instructions to have another hearing if that's necessary, but specifically to address those factors that impact on both the exemption and the child support. And I guess it's right.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and it'll have to be